Let's move beyond the basics. Let's address 3 topics that come up a lot in commercial contract management, or at least generate questions for people new to this area. We'll talk about oral versus written contracts, the capacity to contract, and the term of a contract, or how long it lasts. Oral versus written contracts. The punchline: yes, oral agreements can be enforceable. Doesn't come up that often in commercial contract management. Are they valid? Can you have someone say, "Do you agree?" and someone else say, "Yes, I agree"? Compared to a written contract, where there are lots of legal principles regarding both the form and substance of the document, the type of contract and jurisdiction matter a lot. For example, real estate contracts very often have special requirements based on the common law of that jurisdiction. So it's important to understand that the type of contract and where you are can matter and influence whether or not a written contract is required and the form and substance of that written contract. But there are important advantages for contract management for written contracts. So when you have a written contract versus an oral agreement, yes, in fact, they can both be valid and enforceable. Oral agreements need to have those same 4 basic elements. There need to be at least 2 parties. There needs to be an offer and an acceptance. There needs to be an intent to be bound. And there needs to be an exchange of value or consideration. Sometimes it can be challenging to prove those things in an oral contract. So that's why written contracts have some unique value for businesses and organizations, and they are the norm in commercial contract management. So we prefer written contracts where we can make all those elements really clear and all the terms very clear, and we tend to not like oral agreements for those reasons. That's why during contract negotiation, for example, you'll see disclaimers frequently in people's emails that say this is not an offer or an acceptance. And they're making clear that any discussions they have orally or informally in writing don't rise to a contract. It's only when you have that formal written document on the left that you have an actual agreement.